Hello, ladies and gentlemen. Ron Bellenot again for the informative Bellenot Boufford video series. In this segment, I would like to talk to you about DUI. Driving under the influence is very serious business in the United States these days, and Connecticut is no exception. Our legislature, judges, prosecutors, and organizations like Mothers Against Drunk Driving are committing to keeping the statutes and the laws strong and the penalties harsh for anybody who's arrested for DUI. However, at Bellenot Boufford, we are able to help you eliminate and or minimize the damage that can be caused if you should find yourself arrested for DUI. This is what you need to know. Connecticut law defines DUI as driving under the influence of an intoxicating liquor or drug or both. And when they say drug, they can mean, yes, the illegal kind of drug, but it also means legally prescribed drugs if it impairs your ability to operate a vehicle properly. I'll talk about 3 standards in which you can be charged with driving under the influence. The most common is the per se standard. That is where you are stopped by the police, submit to a chemical test, and your blood alcohol content reading is 0.08 or greater. Then you will be charged with driving under the influence. Another standard is what is usually referred to as driving while impaired, meaning that you're driving and operating a motor vehicle when your ability to drive is impaired as compared to a sober person under similar circumstances. And the third way that you can be charged with driving under the influence is if you are arrested and refuse to submit to a chemical test. That refusal is considered a presumption that you were impaired and driving under the influence. The penalties for DUI are significant in Connecticut. For a first offense, you can be sentenced to prison for up to 6 months, 48 consecutive hours of which is not supposed to be suspended for any reason. However, in reality, the judge does have discretion if he or she sees fit to suspend the entire sentence and assign you 100 hours of community service in lieu of the 48 hours in prison. The fine will be between $500 and $1,000 before court fees, which are significant in and of themselves, and your license will be suspended for a year. You'll also have a criminal record. A second offense increases the penalties dramatically. You can be sentenced for up to 2 years in prison, 120 consecutive days of which cannot be suspended under any circumstances, and there is no exchanging it for community service or anything else. Your license will be suspended for 3 years, and in certain cases, though, you can have a 1-year suspension of your license, and then 2 additional years assigned using an interlock device. And then the penalties again enhance significantly for a third and subsequent offense. In those cases, you can be sentenced for up to 3 years in jail, 1 year of which is mandatory, cannot be suspended for any reason. Your license will be revoked. The fine is between $2,000 and $8,000 for a third offense. It just is not worth it. When you are arrested for DUI in Connecticut, you are facing 2 separate cases. One is the criminal court, and I'll get into that in a second, and the other is the Department of Motor Vehicles. When you are arrested, the police will send information to the Department of Motor Vehicle, and you will get a notice from the Department of Motor Vehicle that your license is suspended on the 30th day after your arrest. If you do not receive the notice of your suspension, do not drive 30 days after your arrest because you will be under suspension, even if you did not receive the notice. And the penalties for driving under suspension, when the suspension relates to DUI, are significant. I will get into those in a minute too. If your blood alcohol content reading was below 0.160, your suspension will be for 90 days. If your blood alcohol content reading is at or above 0.160, you will be suspended for 120 days. If you refuse to submit to a chemical test, then your license is suspended for 6 months based on the refusal. There are other ramifications of refusing to submit to a chemical test as well, which will be discussed later. You cannot drive while your license is under suspension. Do not drive while your license is under suspension. For any reason. The cost is astronomical. You will pay the penalty of a mandatory 30 days in jail, in addition to which it has other significant ramifications for your DUI case, especially if you're a first-time offender. So please, if you are under suspension for DUI, do not drive. Now, the Department of Motor Vehicle will also send you notice that you have a right to request a hearing with regard to the suspension. The hearing will try to determine if you were the operator of the motor vehicle and if the police had reasonable cause to pull you over. Did you submit to a chemical test? And if you did, were the results above .08? And if so, then the suspension is usually upheld. We can help you with these hearings if there are reason to believe that any of those answers are no, that you are not the operator, that the police did not have probable cause to pull you over, and that your blood alcohol content should not have read above .08, then we certainly can help you with those hearings. Now, if you refuse to submit to a chemical test, the refusal is an automatic suspension, unless you can prove that you did not refuse to submit to the test. When you are arrested for DUI in Connecticut, one of a number of things can happen at the police department. They can release you on what's called a promise to appear, where they will have you sign a form promising to appear at your next court date. They'll assign a court date, usually within the next week or two, and you'll be free to go. However, you will most likely be told that your right to operate a motor vehicle is under suspension for the first 24 hours. And then again, it will be by the Department of Motor Vehicle 30 days later again. So do not drive in that first 24 hours. Or the police can assess a bond. And if you make bond, then obviously you'll be released under that bond. If you are unable to make bond, then the police must bring you before the court and a judge for arraignment on the next court business day, at which time you will be held in lockup until your arraignment. You'll be interviewed by somebody referred to as the bail commissioner, who will provide information about you and your circumstances to the judge, who will then decide what your bail is, or if he or she might release you on a promise to appear as well. In all cases, you will be signed again another court date within a couple of weeks. Now, if this is your first offense and there are no serious injuries or other issues related to the DUI arrest, then you have a number of options on how to deal with the case. And we are here to help you assess the best option for you. And we are always fighting to minimize, if not eliminate, all of the damage that you can suffer. You can plead not guilty, or you can apply for what's called the alcohol education program, or you can plead guilty. Now, I have never come across a case in a first offense where there are no serious injuries or other issues where it makes any sense to plead guilty. So that's not going to happen, not at least initially, and we'll have to discuss if there are serious injuries involved in the case, what happens in those circumstances. But you would either plead not guilty, or you will apply for the alcohol education program. Again, everybody's case is different. In some circumstances, it makes a lot of sense to fight the charges. In other cases, it makes more sense to just apply for the alcohol education program. Now, with the alcohol education program, you're not pleading guilty, you're not pleading not guilty. You will apply for the program on your, well, it could be the first of court appearance or your second court appearance after arraignment. The judge will accept the application. You'll have to pay an application fee, and he will reschedule another court hearing for 3 or 4 weeks later. During that time, you will have to submit to an evaluation. The evaluation will determine if you need to take a 10-class program or a 15-class program. And in very rare circumstances, they can also recommend that you have one-on-one counseling as opposed to the group programs for the 10 and 15 sessions. In addition, you will be assigned to take what's called a victim impact panel. That's like another class that's sponsored by the Mothers Against Drunk Driving. If the judge should grant the program, again, you will be asked to either submit to the 10-class program, the 15-class program, or the other sessions, and you'll have to submit to the victim impact panel. In addition to that, you'll have to do 100 hours of community service. And if you do all of this and everything that you're asked to do, and you don't get arrested again or in any more trouble, then at the 1-year anniversary, or wherever the judge reschedules your case for out to the next year, your case will be dismissed. You will not have pled guilty. You will not have been found guilty. You will not have even pled not guilty. You will have been gone through this program, and your case will be dismissed. You can only use this program once. Now, this is significant. When you apply for the program, in most cases, your license is going to be under suspension, either for 90 days, for 120 days, or for 6 months. You can request a deferral of beginning the program till your license is reinstated. That way it makes it easier for you to get back and forth to classes. Again, I cannot emphasize enough the importance of not driving while you're under suspension. If you get caught driving while you're under suspension, not only will you face the mandatory 30 days in jail and possibly more on that charge, but you will be revoked out of the alcohol education program, even if you've completed all of the classes, all of the community service, the victim impact panel, even if you've done everything, even if this is just 3 days before your dismissal, you will be revoked out of the program. You will then be facing the DUI charges in addition to the penalties you're suffering for driving while on suspension for DUI. You could face additional time in jail as a result of the probable conviction in the DUI case having been revoked out of the program. You're going to face additional license suspension because the license suspension for a conviction of DUI is much more significant than the 90 and 120 days or 6 months that you face for the arrest. And there's an additional suspension for driving while under suspension. It basically turns your world upside down. Do not drive while under suspension. It is cheaper and better to pay for a licensed limo driver to take you around at any cost. That is cheaper to you, your life, than being caught driving under suspension. Don't do it. DUI is very serious business. The arrest alone can have significant ramifications. And a conviction, even of a first offense, can turn your life upside down. Financially, emotionally, professionally, personally, your family will probably endure significant burdens based on the limitations that your penalties are going to place on you. And it can even impact your ability to do things such as coach youth sports. However, if you find yourself charged with DUI, call the law offices of Bellenot Boufford and let us help you eliminate or minimize the damage that you are facing. Thank you very much.